has been sought.
Good evening to everyone present here. I, Avneet Kaur, member of Sambhav Initiative and moderator for this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Professor Dr. Akil Ali Sayyad sir, and to all the participants in this 2 weeks National Capacity Building Program on Family Laws, Court Practice, Procedure and Drafting, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy. Where today's session is all about marriage, divorce, and alimony under Muslim laws. It is my honor and privilege to introduce our distinguished speaker today, Professor Dr. Akil Ali Sayyad sir. Sir is currently serving as the founding Vice Chancellor of GM Vastanvi University, Nandarbar, Maharashtra, and also holds the position of Honorary Director at RNP Institute of Social and Legal Justice, CVM University, Vallabh Vidyanagar. His academic journey is both remarkable and diverse, with a PhD in law from Gujarat National Law University and a postdoctoral fellowship from Mediterranean University, Italy. In addition to his legal qualifications, LLM in business law, LLB special, Sir also holds a strong background in science with MSc and BSc in physics. Sir brings with him over 30 years of enriched experience blending teaching, legal practice, research, and academic administration. In his illustrious career, Sir has held several prestigious positions, including Pro Vice Chancellor at Gokul Global University, Sitpur Director and Dean, Faculty of Law at Parul University, Vadodara, Associate Professor at Gujarat National Law University, Gandhinagar, Director, PM Patel College of Law and Human Rights, Anand. Sir is also the promoter and executive director of Prestinia Education Private Limited, director at HGA Ventures Private Limited, and founding partner of GUJ Jurix, a comprehensive law firm offering integrated legal services. His academic contributions include 14 published books with 2 forthcoming, 40 plus research papers and articles, 80 conference presentations, including 17 at international level, 7 major research projects, organizer of 24 national and international academic events. Sir has received numerous accolades, notably Best Law Director in Higher Education by Global Research Foundation, Best Professor of Law by Devang Mehta National Education Awards, Mumbai. Sir is affiliated with several esteemed professional bodies such as Association of Indian College Principals, Indian National Bar Association, Global Alliance for Justice Education, Indian Society of Criminology and Victimology, Federation of Education in India, and many others. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you very much, Ms. Avandit, for very good introduction. Professor Kalpesh, shall I begin or?
Yes, yes. Over to you.
Fine. A very good evening to one and all. At the outset, I extend my gratitude towards Dr. Kalpesh, the founder of Pro Bono India, as well as Ms. Hiranshi, founder of Sambhav Initiative, and of course, Ms. Kaur for a wonderful introduction. I got surprised by knowing about myself. So it was a very good piece of research at her end. Today, we are to talk about marriage, divorce, and alimony under Muslim law. So, I'll just share the slide. Let me share my screen. Is the screen visible now?
Sir, it is visible, but not full screen is visible.
How content only?
So, so full screen करना पड़ेगा.
Is that okay?
Yes, yes, sir, fine.
Hmm. Fine. So we are here on the joint program organized by Sambhav Initiative and Pro Bono. That's about capacity building program on family laws. The hyphen says about code practice, procedure, and drafting. But when you invite an academician and when I have been given the task to talk about the topics, so my much more emphasis would be on the principles of Muslim law, which has been asked for. And at last, we will just talk about the code practice and drafting because more or less is remain the same as per the civil procedure code. So let us begin with today, the fifth session, the marriage, divorce, and alimony under Muslim law. These are the topics which we are going to discuss today, which have been asked by the organizer. The overview of the Muslim personal law. So, what actually is Muslim law? That is a question to many of the student as well as the practitioner also. That since India is a secular country, then how can some law could exist for particular religion? So that is within the scope of personal law. So Muslim law is basically a portion of Islamic civil law, which is applied to Muslims as a personal law. Then we need to understand that what is Islamic law, and just to know what is Islamic law, a part of that civil law, we need to also know what is Islam. So Islam is a religion which is mandate about for the submission to the will of Almighty, that is God. It has been derived from the word salam, that talks about that mean the peace, and the purpose of Islam is to establish the peace. So going further with this definition, this has been elaborated by Supreme Court of India in Lilly Thomas versus Union of India, that the word Islam means peace and submission. Mind well, this is the basic crux of the religion Islam, submission to the will of God. So any person who profess the Islam, he has to submit himself or herself to the will of the God. See, why do I define this? Because when you talk about the law, then every action is going to be judged, is going to be observed, is going to be verified on this acid test, whether it is submission to the will of God or not. And that is how this creates a different system of jurisprudence. And that is very important for we as an Indian, then where we do have a one legal system, the one jurisprudence, then how the religious jurisprudence is get interwoven with the people living in India, where the Constitution of India prevails. So one need to understand first the jurisprudence of that particular legal system, so that you can appreciate that how it has been linked to our Indian jurisprudence. I'll just give you the outline of Islamic law, that it has major 6 branches. Hukukul Ibad, that talks about the human rights, the rights of the people, to be more specific. Siyasat Sharia, that is law of governance. Qaza, administration of justice. Muamalat, that is transaction, which includes the business transaction and other affairs. Jinayat, that is about the criminal law. And Ahwal Shakshiyat, the personal status. That is also a peculiarity of the Muslim law, because here the law doesn't change, but the application of law first verifies the personal status of a person, because this was the legal system developed during the Arabic in Arabia, in such a period where the slavery was been very much popular. So the identification of the personal status is the beginning and the first point, and that is what we will see, that how Indian legal system also has taken this concept about the personal status. Moving further, whatever the actions are we taking in a legal system, then again those have been classified as 8 different types of action. So some of the actions, some of the functions are completely prohibited, and some are mandatorily been asked within the framework of that religion. So that is called first, that is wholly obligatory. Wajib, a second degree of the obligatory, that it is desirable to be done. Sunnah is the professed practice, and that has been considered as highly virtuous, that whatever the Prophet has done, the follower should also follow that, and that is called Sunnah. Mustahab is a kind of thing that it is recommended. If it has not been done, there is no favor or no any punishment for that. On the contrary, there is a complete category of the actions which are been called haram, which are absolutely prohibited. Makruh, which a prudent man should avoid, not to indulge into such activity. Mubah are some of the actions which are permitted in a certain circumstances or in a period of time only. Otherwise, they have been either haram or makruh. And jais are the things which are not prohibited at all. So, considering this, 8 different types of action or a transaction or the practices, the whole establishment of the Islamic law has been there. We'll just take a civil part of that Islamic law and we'll try to apply to the people living in India who profess the religion, that is Islam, and they are being called as Muslim. So the question is, to whom we should identify as a Muslim? The task is very easy. As a student of law, we do have a statutory provision, and that is Shariat Application Act. Here are the sources of Muslim law: the Quran, Sunnah, Ijtihad. That is, it has 2 branches: Ijma and Qiyas, Istihsan, juristic preferences, Istisla, and Taqlid. I was just talking about the who is Muslim under Indian legal system. So, Muslim personal law, that is Shariat Application Act 1939, in its second section itself just identifies all the matters related to succession, property, marriage, divorce, and almost all, except the interaction is between one person with either with the state or with the person of the other religion. So whenever the party to dispute belongs to one religion, that is Muslim, then all of these affairs, for that the law mandates the rule of decision in case where party are Muslim shall be Muslim personal law, that is Shariat, would be applied. Then the question is, who could be considered? Section 3 answers for that, that any person who prescribe the who satisfy the authority, any prescribed authority, that he is a Muslim by profession and by practice, as per the Article 25 of Indian Constitution. He is competent to contract as per the provision under Section 11 of Indian Contract Act 1872, and most importantly, he is a resident of the territories of India. If we satisfy these 3 conditions, then that person or 2 person or the group of people will be governed by the Muslim personal law, that is Shariat Application Act 1937. And this law has also been upheld and found constitutional by various series of judgments under Article 13 of Indian Constitution. So that is how it has the valid legal status. So we know what is Islam. We also have talked about what is Muslim. The part of Islamic law is Muslim personal law, and that is Muslim. And this Muslim, for this Muslim, we will be talking about one particular area of Muslim law that is related to family system, and very again confined to marriage, divorce, and maintenance. So let us move ahead. First talk about the marriage. Marriage, we know that is a very essential element for any of the social system. The world has been formed by the nations. Nations are built up by the societies, and societies are created by the families, and the family gets nucleated with the process of marriage. So marriage is the basic nucleating agency of the family system. Prophet Muhammad Sallallahu Alaihi Wasallam has said that there is nothing like marriage for two who love one another. So that is what is the significance of marriage in Islam. I'll further define what is the marriage in Islam. Hidayah is one of the basic book of Islamic jurisprudence, and that defines the marriage as a legal process by which several process and procreation and legitimation of child between man and woman is perfectly lawful and valid. So it's a legal process, number one. And number two, it has the consequences, that legitimization of children and lawful cohabitation. Section 2 of Muslim Women Protection of Right on Divorce 1986, the very recent legal provision of India, defines nikah among Muslims as solemn pact, mithaq-e galid, between man and woman soliciting each other's for life companionship, in which the law takes the form of the contract, and that contract in Arabic is called aqd. So here is the transformation of the social system, where the two person with very pious purpose have an agreement, that is solemn pact, and for a righteous purpose, that is mithaq-e galid, then it takes the legal form in the form of the contract. And here is the turning point where people misguide with the concept of marriage in Islam. So I further define with the three different definitions that nikah is a union of series and carries a civil contract for the purpose of legalizing sexual intercourse and legitimate procreation of children. That is Bell's Digest. So very much similar to the definition of Hidayah, as well as the Indian statutory definition. Amir Ali, one of the jurists, has defined that as the marriage as an organization for the protection of society. How does it protect the society? It protect the society from the adultery. It protect the society from foulness and unchastity. Abdur Rahim, the other jurist, has observed this as a combination of ibadah, that is the offering to the Almighty, as well as muamala, that is the transaction, the interrelation between the two person. How these are been defined in one single statement, we'll see now. That it defines with the literal meaning, that tie up together is a nikah. It defines as an institution. It talks about the combination of ibadah as well as muamalat. Ibadah is with the Almighty, and muamalas are within the people. We'll elaborate this concept also very soon. It's a mithaq-e galid I just talked about. It's a hisn, that is a fort which protect the people. There is no any physical fort, but it's a system of the people, system created by the people in the form of the fort, that once the two pillars join together, then they are being protected from any kind of foulness of the society, and they remain the muhassan, that is they feel the protected, they become the gentle person, gentle people in the society. So why the marriage should be solemnized? What is the purpose of the nikah? One, to protect the society from foulness and unchastity, to procreate and live in peace and tranquility, the peace which is the basic idea behind the religion of Islam, the way to salvation. And here is that the concept of ibadah and muamalat. There is no concept of salvation basically in Islam. There is no concept of moksha in Quran or in Islam. However, I have taken the word salvation just to elaborate that the success of life. In Islam, the success of life is the success of life in this world, as well as the world after the life after the death. That is either the hell or the heaven. That is Jannah and Jahannam, the concept of that. And that depends on two aspects. That everyone is obliged for hukukullah, that is rights of Allah, hukuk Allah. Al is a conjunction, so rights of Allah, and hukukul ibad. Ibad is the plural for abd or banda. That is any people, any person who is the follower of Islam is abd, Allah ka banda. And that there are the rights of people. See, that is what is the basic difference in Islamic jurisprudence, that it emphasizes over the rights of the people than the duties. Because when we talk about the literal meaning of dharm, dharm talks about the duties of an individual, while the Islam on other way put more emphasis on the rights of an individual, rights towards Allah, that is rights of Allah for his abd, that any human being. Then it becomes hukukullah, and every person's rights with the other person in the society, as a right of father over the son, right of son over the father, right of woman over the husband, a right of daughter over the father. And that is how it talks about the hukukul ibad, the abd. So when you satisfy both of this, and that is what is the only one action, that is the nikah, where both the purpose are being served, and that protects the person from the sin, because it ensures the spiritual purity. Moving further, we can just elaborate that it's not simply a civil contract, but a sacrament. It has a religious concept. It has the religious mandate. Unfortunately, I say unfortunately, in one of the judgment passed by Justice Mahmood a long back, in matter of Abdul Qadir versus Salima, there is an arbitrary dicta that marriage among Muhammadan is not a sacrament but purely a civil contract. That is the arbitrary dicta. It has no any ratio in the whole of the piece of the judgment. It does not talk. It is just the personal opinion of an individual. So today we will first argue and talk about this statement, that whether it's merely a civil contract or a sacrament. And we'll understand that it's not a merely civil contract, but a sacrament. How? Let us see. The Holy Quran enjoins that all married parties to pursue the path of what is called ismat bil maruf. So, for every couple, every party to the marriage has been mandated by the Quran, which is the primary source of Islam, to follow ismat bil maruf. So, there is a mandate from main source of the religion. Second, that it is compulsory in nature. Islam prohibits the celibacy. There is no place for monkery in Islam. That is called rahbaniyat. It is completely prohibited. A man, a woman has to get married unless he or she has some exceptional medical reason or a social reason. Otherwise, it has been mandatory for each and every person who profess the Islam religion. So when celibacy is prohibited, the marriage is being made compulsory, that is nikah is being made compulsory. So it's nothing but the individual is submitting himself to the will of the God, and that is how it's an action of an individual which is further obligatory. And that is how as I mentioned in the beginning of the slides, that it is one of the fard that is obligatory for the Muslim. So it derives the mandate from that. It also from the second source of Islamic law, that is hadith and sunnah, that it is a sunnat mawqida, that the Prophet himself did perform this action in his lifetime, and also asked, advised, and ordered his disciple also to follow that. Moreover, he emphasized that nikah is my sunnah. Prophet has made this statement, that is a hadith, that nikah is my sunnah. Whosoever keep away from it is not from me. That means the Prophet says that I'll consider that as a disbeliever, that he does not belong to me. And the very essential element of Islam is the acceptance of Allah as one and only one Almighty. And the second, that Prophet Muhammad Sallallahu Alaihi Wasallam is his messenger. These two elements are essential for any person to be recognized as a Muslim. And when Prophet himself disowns such a person, then there is a question about being his Muslim. So to remain a Muslim for a Muslim has to be obligatory to enter into the institution of marriage, that is nikah. So that is that makes a sacrament. It's not merely a civil contract. We further get into the terms and condition when the two person solemnize nikah, that nikah nama has been signed. So it's not an isolated instrument. All the terms and condition of this nikah nama have been rooted into the sources of Islamic law, that is Quran and Sunnah. So when a person accept the proposal of any either side, then he accepts that I accept the other person, that is my spouse, as my spouse within the rules and regulation mandated by Islam. So it's not simply the contract, but accepting all the contents of Islamic law, and that is how this contract becomes the legal contract. And that legal contract has the religious mandate. So it's not simply a mere civil contract. The second important point, there is no place for consideration. Again, many of the people misunderstand that with the form of the dower. Dower is something different. That is a right of the wife. We will discuss about this later on, but it is at least not a consideration, which is a very essential element in any of the civil contract as per the Indian Contract Act. Second important point, that declaration of marriage is a compulsory. It's an essential. There cannot be any hidden marriage under Islam. So if there is a nikah solemnized between two person and not intimated to the rest of the world, that will not be taken as a correct position. It has to be declared, and that is always the nikah is been followed by the solemn, that is the uh, that's a preach. The preacher usually deliver speech after the nikah, declaring that these two persons have been married as per the Islamic rituals. In civil contract, you will never find any impediment on the number of parties or the relationship. Two brother can enter into the civil contract, two sister can enter into the civil contract. But here in the nikah, though has a nature of a contract, essence of a contract, but there are lots of restrictions rooted in the Islamic religion, that such a contract cannot be executed beyond the number 4. The gender has to be opposite gender. The same gender person cannot execute such a nikah. The relationship are also been defined in the first prohibited relationship and the consanguinity, that we will see later on. But such restrictions are being put in this contract, which makes this contract a special contract, not mere a civil contract, but a religious contract. It also prescribed the procedure right from the choice of partner to the release the partner from the bond. That is, before making the proposal, there are lots of the series of sunnah and series of ahadith which talks about that how to choose a life partner, how to make a proposal, and also that even in case of there is a divorce, there is a dissolution of marriage, then what procedure has to be followed. So it's a complete procedure been mandated by the religious scriptures. It's a compulsory in nature. We just mentioned earlier also. Any civil contract can be contingent also. This Nikah can never be contingent. Any contract can be for the limited period of time. The nikah can never be for a limited period of time. Among Shia, it was the earlier practice of limited period of time, that is muta marriage. Now in modern time, even that muta is not valid among Shia also. In Sunni, it was right from the beginning, it was not been valid. Analogy of lien can also never been applied in nikah. So it's a contract, but not a mere civil contract. It's such a contract where lots of religious elements are been there, and the purpose of this contract is to not please the individual, but to seek the pleasure of Almighty Allah. So any action which has been done as an obligation, just submitting before the will of Allah, it's a completely religious ritual and religious action, not simply a civil contract. The ultimate beauty of this contract is it lay down a unilateral duty and liability to effectuate Quranic mandate only on the husband. There is not a single mandate on the shoulder of the lady under this agreement of nikah. So when a person says that, when a man says that I accept at a marriage ceremony, that he is saying that I accept the responsibility for providing for my wife, loving her and protecting her. All this are the acceptance on the shoulder of the husband. And as a result of this, despite of accepting the man as a husband, the woman retains her identity. She need not to change her family name. She need not to change her identity to a newer place, newer family, that is Kabila or any of the sect. There is no concept of Ardhangini or better half in Islam. She has the complete status as a person in the eyes of the law. She can own the property, and there is no any right of a husband over the property of the Muslim wife. She can withdraw herself from the marital knot. She has a choice for separation, and the system only lay down all the duties and liability on the shoulder of husband, not on the wife. So in short, we can say that though the nikah has a nature of civil contract, but definitely it's a sacrament. It's not just a simple civil contract, which has been many of the time misunderstood and misconceived. So to my all teacher friend, now when go to the class, I think they will keep this point in the mind, and even while framing the question regarding this, the concept of Muslim marriage. It's not a mere civil contract. Moving further, that what are the essential elements of nikah? The proposal and acceptance, capacity to contract, and absence of impediment. These are the three essential elements. We'll just look at one by one very fast. That proposal and acceptance has to be direct or indirect, but it must be in the presence of witness. It has to be only in one instant or in one meeting. If it has been made a proposal in one meeting and the answer is not been received, that ijab, that is proposal and qabul, is not been made in the same meeting, and there is another meeting, then once again that proposal is to be made before the person for an acceptance. But again, here are some of the misconception that only a male can make a proposal and the wife has to, the lady has to accept. No, it's not that. Either of the party can make the proposal and the other party can accept or reject that. And this acceptance and proposal and acceptance is always along with the door. What's door? We'll discuss later on. That door is a sum of money or a property for which the wife is entitled to receive. So that is the property or the money which has been handed over by the husband to the wife as a mark of respect. We will discuss this later on. Capacity to contract marriage, that is the age, puberty, option at puberty, Carol Billag, soundness of mind and religion. So here also it puts the condition that only person of particular religion, that is Islam, can enter into the contract of this marriage, that is the nikah. If this exceptionally has been considered as the civil contract, then there could not have been this mandate of being a religious. So the party to this contract, that nikah, must be of the same religion, that is Islam only. However, in certain cases, if there is in certain cases the female is not of the Islam, but if she is from the sect that is Kitabiya, the religion which follow the books, holy books, in present time we can consider the Jewish and Christian, lady can enter into the contract, that is nikah, with the male who is Muslim by religion. Absence of impediments, this also makes this contract a religious contract, not a civil contract, because it put the prohibition on polyandry. It put the prohibition on the relationship of incidents and dissidents, sibling, maybe the step brother or a step sister, or the parental side, even the father, grandfather, or children, grandchildren. And the same relationship with the affinities, like relation which have been prohibited in absolute prohibition in Islam, the son, daughter. Similarly, all the relations or the sibling on the part of the spouse also will be prohibited relationship. That we'll discuss in detail further. Fosterage also makes one of the absolute prohibition. The relative prohibitions are about the number of wives, that Islam restricts the number of wives to 4 only. That is the only religion which put the explicit restriction on the number of wife, that can never exceed 4. By chance, if it exceeds, then the one has to correct that. We'll discuss that part later on. The absence of proper witness and any of such impediments are there, then because of that, the validity of nikah may be either sahih nikah, which creates the rights and obligation, or batil, which will be considered as void ab initio, because it is laid down on a bad in foundation. Or there could be a fasid, that is irregular marriage, that which may be valid, but because of some irregularity, like any of the relative prohibition, if the number of wives has become 5, then the husband has to divorce at least one, so that again the number is been limited to 4. As long as that is the 5th wife, then that marriage with that fifth wife will be considered to be irregular. Similarly, the marriage with the sister of the wife, that is what we call a sister-in-law, is also been prohibited. However, if he divorce one of the lady, then it becomes it can be corrected from irregular to a regular. This restriction or the permission in number of marriage, that is related to polygamy, is again a misunderstood concept, that Islam does not mandate or encourage a man to marry more than one wife, rather puts the restrictions. In chapter number 3, ayat number 129, the Allah states that marry more than one woman only if you can treat them absolutely equally in all matters. Absolute equally as well as in all matters. Then only this permission. If you cannot do so, have one woman as wife. This will prevent you from injustice. So marrying more than one wife and not treating them absolute equally in all matter is an injustice, and a person should not indulge into any activity of injustice. And that is further, the ayah says, beware, you may not be able to do equal justice to two or more wives, even you want. That a man, a human being, can never treat two person equally in absolute manner and in all matters. And since that is not possible, that the Allah Himself says that, so the mandate is to restrict only to a one woman as a wife. Exceptional cases only that number may be allowed. Otherwise, that is what is the concept of polygamy in Islam, that one should marry only a one woman as a wife. With this, let us move further. That we were talking about the essential of nikah, and this is one of the most essential element. That is just and most essential element is the mahar. That mahar is called a dowry in English. That is the sum of money or a property which wife is entitled to receive on the occasion of the marriage. A husband is bound to give away this property or the sum of money to wife, and there are four different types. One is specified mahar, that is mahar musama, that is fixed under different sects. A proper mahar, that is maharul misl, that is customary, one can decide based upon the position of a wife, social position of her family, custom of that particular locality, and status of husband, because socio-economic condition also is to be considered while deciding the amount of mahar. So that is called proper mahar. This, whatever the amount has been fixed, either proper or specified, is to be given away to the wife either immediately or promised to be paid later on. And based upon that, that is a classification. The promptor, that is muajjal or muvajjal, that is deferred, would be paid later on. That has been extended or been taken an extension for payment, that is called muakhar. Something is been postponed. However, this is an essential condition for marriage. If that has not been paid or that has not been decided, then the marriage will become a void. It is an essential element. It's an obligatory gift from the husband to the wife as a mark of respect. In a Latin system, there is a phrase, donatio propter nubitus, that says that the free gift on the occasion of the marriage. So it has a very resemblance with the Latin system of marriage. A wife has an absolute right over in any condition. This right can never be waived, and even the wife is not supposed to waive that her right, except in certain circumstances. It also provides the financial security to female, that wife. And if the wife has, sorry, if the husband has not paid, if it has been deferred, then as long as it is deferred, it remains debt on the husband. Mind well, this is not the consideration as per the civil contract, and it's not also a dowry as it has been observed in other social systems. So mahar has a very essential ingredient for any marriage, that is nikah. With this different forms of marriage, let us talk about the dissolution of marriage. The marriage can be dissolved either by act of God or act of parties. By act of God means if there is a husband, so death of the husband or a wife, the marriage gets automatically dissolved and the other person remains a single. So the marriage gets discontinued. The act of party could be through the process of divorce, and this divorce could be extrajudicial or through the judicial procedure. where the woman can approach the appropriate court under the provisions of Dissolution of Muslim Marriage Act 1939. And in extrajudicial, again, there are different classification. Either the husband can initiate, or wife can initiate, or mutually both of them can enter into the dissolution of marriage. Let us see the Islamic concept of the marriage. Islam, though, permits the divorce, but considered that to be the worst of all permitted things. That is, it is the most disliked action of the person, which is though permitted by the God, but is not been considered as a good one. That is called abd al-mubah. So it is mubah only in special circumstances it has been allowed, otherwise it is not been allowed. So as we have discussed earlier also, there is a category of the actions which are called mubah. So mubah says that under circumstances in a particular interval of time only that has been allowed, otherwise this divorce is not been allowed. In the pre-Islamic condition, the divorce was just a fun and game for the males. So there was the system was to reform, and the Islam put all the restrictions on the husband, that husband can never exercise talaq with arbitrariness or irrational or unreasonable manner. So the husband has to establish that his decision or his action was not arbitrary, was rational, and also reasonable. If it is found on the part of husband that it was an arbitrary or irrational or unreasonable, he is liable for that action will be considered as sin under the Islam. The condition also is such that it has been discouraged, except there are certain conditions or the procedure to be followed. What is that procedure? That has been mandated in Quran. Before that, let us see that what Justice Krishna here has stated in one of the judgment in 1971, that indeed a deeper study of the subject discloses a surprisingly rational, realistic, and modern law of divorce. So though the law is 1400 years old, Justice Iyer observed this as a rational, realistic, and modern law of divorce, because that is the essence. One need to understand that rather just knowing about the superficial sayings about the divorce. And today we will see that how that the process of divorce is also a very religious and also the rational and reasonable, so that there is no any kind of injustice with anyone. Quranic mandate is that in chapter number 4, ayah number 35, it talks about Quran enjoins that effort must be made for an amicable settlement, for which two arbitrators should be named, one from wives and the other from the husband side. And if they do their best to reconcile them, the God will do good. I'm not talking this, the statement is not from the law of arbitration. It is not from the modern law of arbitration conciliation. This or any family court, court act. It is from Quran. This is what the Quran has mandated for the arbitration as one of the mandatory procedure before pronouncement of the divorce, before entering into the procedure of divorce. So unless this step and the stages of arbitration are not been made by the couple, then such process of divorce will be considered as a sinful. And that is what, for every husband, the Quran says that you may dislike something about your wife, but maybe God has put in her some good for you. So most of the time where the male complains about the wife, just to answer that and to put a permanent prohibition on that, the God says, addresses to every male that even though you say apparently that you do not like something in your wife, despite of that you have to continue that relation, because the God has put some better thing, some good thing in her for that particular male. So if any person understand this, then will never enter into the process of or procedure of divorce. However, in exceptional case of incompatibility, who find this incompatibility or who will decide this incompatibility? Not an individual, not the mother of the woman or not the father of the son, but the two arbitrators, one from the woman side and one from the man side. When they sit together and make their all attempts to settle down the issue, and if they do not arrive to any of the compromise, then in case of exceptional case of mutual incompatibility only, the divorce can be granted or divorce can be initiated. So what are those steps? We'll see that. The first way is from husband. We'll talk about the three modes from the husband side. That is talaq ahsan, or talaq hasan, or talaq bidat. Talaq Hassan, as the name itself says, that is one of the best way to get divorced from the marital law. That there has to be pronouncement of talaq, that expression of giving away the talaq, or the willingness or expression to break this marital knot, and it has to be during the tuhar. What is tuhar? Tuhar is the period, the time period between the two succession menstrual cycle of the lady. So if the wife is under the menstruation and the husband has pronounced a talaq, then during that period also that talaq will not be considered. It has to be between the two menstrual period, that is the period of purity, that is called tuhar. After that, both the couple are supposed to stay together under the one roof. There is a possibility that they may again reunion. So if they get reunion, if they enter into the sexual activity, either express or impliedly, then such talaq will be considered revocable, and the talaq will not get materialized, will not be effectuated. Even if the iddat has been concluded, then also the same couple have the enter into the remarriage without any other procedure, because it was been only one talaq, and such actions can be twice in the lifetime of that couple. It becomes irrevocable only after the iddat of the third pronouncement during the tuhar. So, if someone has pronounced talaq in the period of tuhar, and then during the period of iddat, if they again expressly get reunited, then there is no talaq. They can continue with that marital knot. However, if the period has been lapsed, that is whatever the mandatory, we'll discuss at the end of this, then also again the same party can remarry without any other procedure, and that is what is a valid marriage. After that that marriage, even if required, and there is a second pronouncement, then also the marriage can be again revoked. So Islam provides three lifeline for divorce to get effectuated, and that is the best way of getting divorce. In case of Hasn, that is a little limited, that the pronouncement has to be during Tuhar, as it was there, as it was in Ahsan also. That party has to stay together under the same roof. However, it also becomes revocable during the period of Iddat, either express or by their actions. And after second pronouncement during the consecutive Tuhar, say during the Tuhar, and they do not reunion, then there is a second period of Tuhar, that is after pronouncement, the wife has undergone one menstruation period cycle, and then there is again the period of purity where the husband has pronounced the second divorce. So it was the iddat period of earlier one, and thereafter again during that second tour, if they get reunion or they have a sexual intercourse, then the earlier divorce will be revoked and the marriage will continue. Marriage will not be effectuated. However, then it becomes ahsan. But even if in second pronouncement, in the second tuhar, if there is no reunion and there is a third tuhar, where that is the second menstruation, after the second menstruation cycle of the first pronouncement, if there is a third pronouncement of talaq, then it becomes irrevocable. So here, compared to that Hassan, there is a consecutive three pronouncement. During the three consecutive to her, then after third pronouncement only it becomes irrevocable, and thereafter the party cannot remarry. Then the party becomes a stranger for each other, and they cannot remarry the same couple, because Almighty has given them three chances to reunion and maintain their marital knot. But if they have failed that, then they cannot remarry unless certain conditions. So that is the one of the hasn, good way of divorcing the wife. This third way is a very bad, and that is a triple pronouncement of the talaq in the same instant. Supreme Court has already stated in Shaira Banu versus Union of India in 2017 that it is bad in theology, and that is been held as illegal and void. So there is no question of this talaqul biddat in India. And even if someone practices that, then there is a provision. There are provisions for punishment under the Muslim Women Protection of Rights under Marriage Act 2019, and the wife is entitled to seek the subsistence allowance from the husband, and it becomes an cognizable offense for which there are the provision for punishment. However, the offense is cognizable. So these were the types of divorce on the part of husband. Wife also has a right, that is called khula. That is a right very parallel to the right of talaq, which has been with husband. Uh, there could be unconditional desire of wife. Wife need not to give any reason for initiating this talaq, that is khula. However, as there are a provision for reconciliation before the talaq, here also there will be at least the attempts would be made for the reconciliation. However, if that does not materialize, then the wife can seek the separation. Husband definitely can discourage the wife, but cannot say no. He has to accept the wish and desire of the wife, and has to agree with this khula. Here, for convincing the husband, the wife has a choice to forego her door. It is not mandatory on the part of wife. It is just its choice that she can waive the sum of mahar which was for which she was been entitled. And as a result of this, just like a talaknama, there could be one document signed by the qazi or any authority that is called khulana. So that is one of the valid form of divorce or separation. Third and important is by mutual consent. That is talaq-e tafweez or mubara. Mubara is the kind of mutual agreement, and recently the High Court of Gujarat has passed the judgment that when the two parties to the marriage under Islamic law has entered into the divorce with the mutual consent, mutual separation, then they do not need any kind of legal procedure. They can directly seek for the decree of divorce before the family court. So that is Mubarak. Talaq-e-Tafweez is kind of a proposal which can be initiated from either of the side, and they can enter into another contract where they can mutually agree upon the separation, and that is called the Talaq-e-Tafweez. With this out of court or extrajudicial form of talaq, there are legal provision also, that is under Dissolution of Muslim Marriage Act, and it specifies 9 different grounds that if husband has been not known for 4 years, if he has failed to provide maintenance for 2 years, if he has been imprisoned for 7 years, or if he has failed in performing the marital obligation for 3 years, or is been found impotent at the time of marriage, or has been insane for the period of 2 years, or the wife has attained to the age of puberty, that is 15 years, and she wants to repudiate the marriage. If there is a cruelty on the part of husband, the cruelty which includes the habitual assault, evil repute or infamous life, or the husband pushes lady to immoral life, or the husband disposes her property or prevent lady from exercising her right over the property, or he obstructs her in observance of religious profession, or does not treat her with equitably in accordance with the injunctions. In any of such case, or any other ground which has been considered recognized valid under the Muslim law, the wife can seek divorce before the appropriate court. So that is the provision before the court of law. Woman can seek that divorce under this statutory provision. We discussed the mutual consent, that is extrajudicial. What is the effect? The effect would be, effect of divorce would be the cohabitation become unlawful. The wife requires to observe iddat. We'll see what is iddat. During iddat, the divorced wife is entitled to be maintained by the husband. Unpaid dower, if any, dower can never be unpaid. It has to be, even if it is deferred, has to be paid before the divorce. But if it is unpaid, that is deferred dower, becomes immediately payable. Both the parties are free to contract another marriage, wife always after the iddat period, and the mutual right of inheritance on each other's property, that also says for each of the spouses. This divorce also leads to the final stage of the separation, and that is iddat. Iddat is been word derived from the counting. The Arabic meaning of counting is iddat. It's a mandatory waiting period for a Muslim woman after the dissolution of marriage. And as and when she has a knowledge of divorce or the death of the husband, the moment this period, waiting period commences. So it's an immediate action on the side of the wife. It has a very essential element that it's it is to ascertain the paternity or the pregnancy of the wife at the time of, because this was been, the divorce, if it has been pronounced, has to be pronounced during the period of purity, not never during the period of menstruation. So uh, 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 to ensure the paternity of the child, this idyat is to be observed mandatorily. It also serves as a period of mourning for the wife in case of the death of the husband. It also provides the period for the reconciliation. So, as we discuss about the talaq al ihsan or hasan, this iddat is the period during which there can be attempts for the reconciliation. Remarriage under Sunni is fasid, and it's batil, that is wide among Shia. This iddat has a unique feature of legal, social, and ethical obligations on the part of both the party. The duration of iddat in case of divorce, if it is the marriage is not consummated, there will not be any iddat. There is no need for wife to undergo iddat, because there was no any consummation and there is no any question about either the pregnancy or the paternity of the child. However, if it is the marriage has been consummated, then the period of iddat shall be 3 menstrual cycle. In case the woman does not menstruate, that is in the period of menopause or any other medical condition, then this period of iddat is 3 lunar month. Islam follows the lunar calendar, not the solar calendar. In case of death of husband, it is 4 months and 10 days. Whether the marriage is whether the lady menstruate or do not menstruate, that is the 4 month and 10 days compulsorily for all kind of women in case of death of the husband. However, if at the time of divorce, if the lady is pregnant, then the period of iddah shall continue till the time of the delivery of the child. Once after the delivery of the child, only she can remarry the other person. Till that, she would be considered as the wife of the earlier one, and the iddat will continue, because that iddat is a time frame within which the it gives an opportunity to husband to revoke that pronouncement or the divorce. In case of uh, death after the divorce, that is, if there is a divorce and the wife is under the iddat for 3 menstruation cycle and the husband dies, then the period of iddat will not remain the 3 lunar month or 3 menstrual cycle, but it will be extended to 4 months and 10 days. During the iddat, the wife has right to receive the shelter and maintenance. This maintenance will just talk about the maintenance after this slide. After the conclusion of iddat, divorce becomes irrevocable. These are the effect of the conclusion of iddat. Woman can remarry except the earlier one. Of course, the rest of the people, uh, because it is one of the relative impediment. Succession and inheritance ceases mutually on each other. If the husband dies during the iddat, then the right of inheritance opens up to the wife. That because now it has been considered, she was been considered as a wife of that deceased husband. Uh, if there is, I already said that if there is any deferred or has to be paid, ought to be paid immediately, and right to maintenance gets shifted. Muslim Women Protection Act 1986 mandates that right to the other side, because after the dissolution of marriage, the lady do not remain the member of that family. She returns to the paternal family, and the responsibility of the maintenance become to the father side. And in case the father is not in a position to maintain, then as per the dissolution of Muslim Marriage Act 1986, and as it has been mandated in Delhi Latifi, uh, the right to maintenance will be shifted to the Waqf board, and that is what is a debate nowadays. So these are the basic principle of maintenance, that is nafka. A man is obliged to spend on his family for food, clothing, and lodging. Everything. It's the responsibility of the man. There is no any such responsibility on the shoulder of the woman. He has responsibility towards wife, towards relative, that is children, grandchildren, parent, and all others. So it goes beyond the provision of maintenance under criminal procedure code or even BNSS. It also includes the servants, because during the period of Islam there was slavery of been observed. So a man is obliged to maintain all this category, and there is absolute obligation towards the wife, whether the wife wishes or not. It is an obligation, absolute obligation on the part of the husband. The maintenance could be in the form of karche pandan or meva kohri and other things. We would just conclude this very soon. I think the time is of 1.5 hours, right?
Yes, sir, yes, yes.
Yeah. Mm. So we will just conclude. Someone has raised the hand. Uh, would you like to discuss this now, or shall we discuss at the end?
So we'll take up, sir, at the end.
Okay, okay. Someone has raised the hand. So I think Mr. Arun Jindal, you can wait just within 5 minutes, we will conclude. And that is what is the essence about the drafting and pleading. See, for Muslim law, there is no separate kind of drafting or pleading. Since the Muslim personal law also is based on the similar legal system, that is adversarial legal system, the procedure remains the same, and all the general rules of civil procedure code also applies to all these litigations under Muslim personal law. Only addition is the specific legal principles which are not been there, are been mandatory, be need to be mentioned. So in such drafting or pleading, it is very essential that the declaration that the party to the dispute are Muslim as per the Shariat Application Act 1937. If that has not been stated, the person will not be entitled to take the benefits of the Shariat Application Act, rather the Shariat Application Act will not be applicable. And similarly, the scope of litigation, which I just mentioned in the beginning, the section 2 talks about the series of actions like property, disposal of property, even work, even maintenance, divorce, separation, everything. The scope have been mentioned. So one has to declare in a very initial stage of plaint itself that the party to dispute falls under the definition of Muslim as per the Sharia Application Act, and also the scope is within the scope of personal law which have been mandated in section 2 of the Sharia Application Act. When you do this for all codified part, it is very necessary to state the exact statutory provision and what exactly the specific remedy has been sought. Most of the time it has been observed that the practicing lawyer come up with a very vague statement of either the provision or very vague statement of the remedy. So in such case, it will be very challenging for the court to grant any kind of relief. However, on the other part, if there is any uncodified part or the scope, then it becomes further essential to establish that whatever the procedure was been adopted like extrajudicial procedure of divorce, whether it's a talaqul hasan, talaqul khula, or Mubara, then whatever the whatever the customary or Quranic mandate were been there, religious mandate were been there, have been strictly adhered. If that is not been mentioned in the plain, then you may lose your taking advantage of any of these legal provisions. And for such every actions, you need to have at least two witnesses as per the personal law. So the suggestion would be just to take care that you do not simply write the story, but state the material fact about the parties. Number one, party to dispute are Muslim. The scope is under the Shariat. Then what are the key feature of the material of the facts? Then the factual basis. What are the fact? One, the material of the fact, the basis of the facts, and uh, the court has the right jurisdiction. Most of this such matters today which we have discussed, except the inheritance and other things, all are before the Family Court Act, and family court has the jurisdiction. Then the specific relief has to be stated. The issues are to be properly defined so that it helps the bench to look into the specific remedy which has been sought. And if the things have been completely in compliance with the procedural law, your plaint can succeed either way. So I just conclude from my side. If anyone has any question, we can have clarification on that. And then,
Good evening, sir. Very good evening, sir.
very good evening.
Sir, I have a question, sir. Islam is divided, as we all know, Islam is divided into two sects. One is Sunni Islam and one is Shia Islam. India being a major Sunni Islam country, for suppose if a Sunni boy get married to a Shia girl or vice versa, so will the Muslim laws apply equally to both of them, or how will that take place if Sunni boy is getting married to a Shia girl or vice versa, since both are the two separate sects of Islam? And does the Muslim law covers every type of Muslims, like Pasmanda Muslims also we heard in the news? So about that I wanted to know, sir.
Fine. So I really appreciate a wonderful question. And you raised the two questions. Number one, you just talk about um, the party to marriage are maybe different from different sect, one Sunni and one from Shia. As I stated earlier also, even a Muslim man can marry a non-Muslim woman who is Kitabiya. That is the lady from the religion the lady professing a religion which is based on the book. So in modern days, the Christianity or Jewish. So a Muslim man also can marry a Jewish lady or even uh, Christian lady, and that will be considered as valid nikah. However, in case of a dispute or in case of the subsistence of the marriage, the Muslim law would be applicable, right? No Christian law would be applicable because the marriage has been solemnized as nikah. So Muslim law has been applicable. So the law of that husband would be applicable since it has been a marriage has been a nikah. Similarly, in a matter drawing the same principle, if in a party to marriage, if one is Sunni and the other is Shia, then whatever is the sect of the male that shall be followed for the application of the either the Sunni principle or the Shia principle, irrespective whether the lady is from Shia community or from the Sunni sect.
Sir, and my second question was,
I remember. Is that clear? Is that satisfactory for?
Yes, sir. Yes, sir. I got it. So the male has to be the
Yeah.
dominant part.
No, it's not a question of dominance. It's a question of the proposal and ijab and kabul.
Yes, sir.
So he has taken the responsibility of maintaining that wife. So he would be obliged to maintain the wife only according to his legal principles.
Yes,
He
sir.
cannot maintain someone following the principles of the other,
Yes, sir.
which he does not
So
follow,
I
right?
got it, sir. If male is
So
Sunni,
it's
then
not
it
a
has
kind of
to.
a privilege. It is
Yes,
a
sir.
binding on him that he has to follow his sect only,
So
right?
I got it, sir. If the
Yeah, fine. And the second important point, there is no any kind of pasmanda Musalman. Musalman is only a Musalman. Anyone who recite the kalma, that is La ilaha illallah Muhammad Rasulullah, on anyone who declares that none other than the Allah is able is capable of worship, and Prophet Muhammad sallallahu alaihi wasallam is the messenger of Allah. Whomsoever accept these two conditions, then he is a Muslim, he is Mu'min, he is following the Islam. Pasmanda is kind of a classification, a modern classification based upon the socio-economic status. The religion does not discriminate on the basis of any race or any creed or any kabila or any other sect also. And that is what is been said by Allama Iqbal, that एक ही सफ में खड़े हो गए महमूद और अयाज, न कोई रहा बंदा न कोई रहा बंदा नवाज. So even a slave and a king, when are been aligned for praying the Almighty in the namaz, that is salah, then there is no any distinction between that the person offering the prayer, whether he is a slave or a king. They have to stand in the same queue, same line. That is what is been called equality before the law. Here it talks about the equality before the Islamic law, equality before the Islam, equality before Allah subhanahu wa ta'ala. So there is no any classification of Pasmanda. Pasmanda is a modern concept, just classifying the Muslim who have been, and particularly in India only, who have been considered as other backward class or economically backward class or any other category which the state or the government might have identified. Yes,
We will take
other
up two
question?
questions. Arun Jindal followed by Ekta Pandey. So this will be the two last question. Yes, Arun.
Yes, sir. Hello, sir. My question is, suppose a man who is a Muslim and he is in some issues with the wife and he is into matrimonial dispute with the wife. So, in that particular case, can he remarry? Can he marry to someone else? Because he's actually polygamy is allowed. But the point is, if he cannot be able to treat both the wives equally in that particular case, so will he be allowed to remarry under the Muslim personal law?
See, the answer could be of two, that religiously he shouldn't marry the other, because then he would be, his action would be sinful, because he is not he won't be in a position to give justice to or treat both of them equally. However, in a modern times or in a practical way, if you look at to the situation where if the lady herself has deserted the husband and she has preferred to stay somewhere else, then at least for that period of time, under those particular circumstances, the husband is been relieved from that obligation to treat that particular lady, because he can treat equally only when the earlier, the first lady is staying together with him only. So if that is not the choice left by that lady who has deserted him, then in that case, practically he can marry the other lady.
But in the case of matrimonial dispute, then the lady could also be residing with the husband, and she may not be deserted, but still the matrimonial litigations are going on. In that particular case, how you justify that the husband is treating both the women, means the first lady and the second lady equally?
See, that is what I said in the beginning of my answer, that it religiously he cannot, because he won't be able to treat them equally. But practically, when you look at the situation, because then it based upon the situation and circumstances. When the situation is such that he is not in a position, when the circumstances are such where he is not in a position to provide any kind of treatment, forget about the equal treatment, any kind of treatment to that the first lady, then just to save himself from entering into any unfallness or adultery, it is better that he remarry to he marry to the second lady.
So one more question I'm having.
I think you had raised 3 or 4 questions. Let us take the other question also. My phone number and email IDs have been there in PPT. You can
Yes,
contact
yes.
at any
Sorry,
point of
Arun.
time.
Yes. So we'll take up last question. Ekta Pandey. Ekta, are you there? Sir, because of this complication, I failed in family law in my LLB days. So, and especially
No,
it's
there is
really
no any
difficult.
complication at all. There is no any complication at all. It's very simple. Only the thing
Family
is
law,
to understand properly. And
family more than 5 years.
the 1 hour is very less time to talk about everything. But
Yes, sir.
it's very simple. There is no confusion at all. So I am open as an academician. You can approach me at any point of time.
Yes. Ekta, are you there? Yes, Prachi, are you there? Prachi.
Yes, sir.
Yes,
Now, would
over to
like
you.
yes, sir. Thank
Sir,
you, sir. On behalf of organizing committee, I extend a sincere gratitude to you, sir, for today. We are truly thankful for you too, sir. Not only for accepting our invitation, but inspired to all our participants. Thank you, sir.
Thank you very much. Thank you.
yes, thank you. Thank you very much, sir.
So shall we conclude?
Yes, sir. Yes, sir. Thanks.
Yeah,
Thank you very much, sir.
I think my phone number would be displayed or there. Instead of making a call, you can you prefer the SMS.
Okay.
Thank
I will
you.
share in the group. Yeah. Okay. Thank you.